favorite. It's whenever I ask questions and no one responds, it's like, yeah. Well, I guess you're still paying, I guess. I don't know how all this is working. Okay. All right, let's see. Let me bring this with me. I guess I don't. Cool. All right, let's pull this open here. Turn on the chat thing so I can see if that thing moves. All right. Evidence. This is chapter 10, where the exclusionary rule doesn't apply. Open fields, that's where we left off. Open fields in plain view. Excellent. Let's see what the next one's about. It's chapter 11, or is that chapter 10? That's chapter 10. Chapter 11, go back into hearsay stuff, administrative searches. Okay. Boom. Fashion stuff, that seems out of order. I might jump around a little bit. I think I'll do identification before I do that. Just evidence. Search warrants, computer wiretaps. Yeah, I think that's what I'll do. I think I'll hop around a little bit. Simply because I like to move these things in a particular order. I like to kind of keep them chunked up together. All right, so that one's there. And then Bring on that one down. 13. Yeah. Oh, field. So all right. Let's see. It is still not quite time. We have less than 60 seconds. Then we'll begin. You fields also do a little bit of touch in between. All right, it is officially 1 o'clock. We have people here. I'm glad that people are here. And let's see, last time we left off, we were talking about plain view and open field searches, that kind of stuff. And so we'll pick up with that, and we're going to stick with the Fourth Amendment stuff a little bit. So we'll talk around in terms of chapters. This next chapter is pretty small too. So there we go. So as I said last time, it's as you're dealing with these two things, these things technically are not searches. Plain view and open field searches. The reason why they're not searches is there's no reasonable expectation of privacy. And so that's that big thing that we were talking about last time, is that reasonable expectation. And since that's not there, it's not an exception to the rule, it's not even applicable. When we start talking about, start with open fields or plain touch. Open view. So open field and open view. I like plain. Start thinking open too much. It gets confusing. So we'll start here with open field stuff. Basically, once you get out beyond the curtilage of your home, which we talked about last time, those factors, there is no expectation of privacy, no matter how well fenced in you have, how concealed it is, purpose of its use, any of those things. There's no protections there. And so you basically have that situation where, yeah, you can just walk right up there if you want. You have to make some distinctions if you're going to deal with buildings and that kind of a thing, because you have to be able to distinguish it from, you know, a public use kind of a thing versus not. But yeah, there's no protections there. Basically, what you get at with that is things like barns, fields. Think about all the different types of rural areas. I mean, that's basically what you're doing there. Not always, but for the most part. Plain view is a little bit different than that. Open fields, you can do anything you want to. Touch is included in this. This one doesn't have touch. There is no touch associated with this. Let's see if I go into the next slide. What does it say? Plain view or overview. Principle that if a law officer is where he has a right to be, evidence seen, contraband in plain view can be seized and used in trial. So, I think 5 cents is implied and immediately apparent. That's not exactly true. I mean, we'll use it for the book, but that's not exactly it. This is no touch. If you touch it before you have met one specific standard, it's not immediately apparent that it is contraband or that it is evidence, you have no ability to touch it whatsoever. You touch it and you don't know immediately before touching it, can't use it. I can't remember the name of the case, but basically what it was is it was a theft. They were it's a search warrant of an apartment, I think, and while they were there, they saw one of the officers on the scene saw that stereo matched the description of one we had a stolen report for. All he does, moves it, records a serial number, and looks it up. Nope, can't use it at all now. He touched it. He touched it first. It wasn't immediately apparent. There was some questionability there, but you couldn't make that distinction. You have to be able to make that distinction. And without that, so that's why it's like no touch kind of thing. Now, where things will start to get a little bit more convoluted a little bit, there is a concept called plain touch. When that happens, you're really talking about these kinds of things here, incidents. You'd be talking about that incident to an arrest, that's a full search. So if you've got that probable cause, or more likely what you're talking about here, a stop and frisk, right? So whenever you do a stop and frisk, this doesn't go into that at all, but it's related to that. That stop and frisk, the purpose of that is only for officer protection. Because of that, it's very limited what it does. Right? You can't go into somebody's pockets. You feel a lump in their pocket. You can't tell what it is. You can't go after it. But if it's immediately apparent to you, you can't. Right. So if I frisk somebody, it's like, okay, I know that's not, what, a glass pipe in his pocket. It feels more like a gun. Is it a gun? Yes, that's definitely a gun. Getting out. Yeah.
What if you also, you frisk and then you say, can you empty your pockets? Then they can get out.
They don't. If you're going to do an arrest, you can do that. Because at that point in time, you're having them turn out stuff. It's one of those things that you kind of get a little bit in that consent thing, where it's.
Well, he did it willingly.
Mm-hmm. And so it's going to be the parameters of how you're there. That's that element about where the officer's standing right here. If the officer is where he or she has a right to be, that's the biggest element of it, is that you have that probable cause to effect a stop if you have to have someone stop seeing like the car, or that like you have a legal right to be where it is when you see it. It's like if I'm walking by a house, I see a window over there. If I can see in that window that there's crime going on, fine, right? However, if I'm in their yard up next to their house peeking in the window, it's not the same thing. Right? So that's a bit different. Yeah. Actually, I had an officer who did that once in a small town many, many years ago. Would go up in people's windows and peek in. Super creepy. Did not keep that job for long. Yeah. Well, that job there. Yeah, and so if you have got a legal right to be there, you're good. As long as you can see it and you don't touch, and it's immediately apparent, then you can touch. And the five senses may provide information, make it immediately apparent. No, because if you touch beforehand, you're in some trouble. Now, originally, plain view, this slide what it speaks to is a little bit about the history of its development. So plain view, whenever it originally started, like any other case, the factors that influence that specific incident were the ones that determined whether or not it applied. And in this case, what it was, a person had been pulled over and in the process of getting out of the vehicle, they had dropped drugs right in front of the officer. I pulled you over for some reason, completely outside of this. That's just right there, though. I'm gonna have to do something about that. And so he gets arrested, and that question comes up. And that's where the inadvertence came from. Originally, it was an inadvertent situation that led to plain view arising. Over the years, though, another case came up that challenged that. And that's no longer the case until, they must discover incriminating evidence inadvertently. That's actually an old one. That's been overruled since the 80s. They'll stay that next. It doesn't look like they actually stay with that in the next slide. Oh, I'm disappointed if they didn't. Yeah, because that's that rule no longer applies. Inadvertence. It was an original requirement of it. Inadvertence no longer applies that. Good God, I hope there's not a question about that because that would have been one I wouldn't have paid attention to look for. So that's an old one. Again, immediate appearance. Open fields, any unoccupied, undeveloped area outside of the curtilage. I mean, neither open nor a field as there in common speech. So it doesn't actually apply to open or fields. It's just anything that doesn't have that expectation of privacy attached. So that's basically what they're getting out of that. Good faith. I've already talked about good faith. Good faith or about honest mistake. Only on good faith. Yeah, we already talked about that. Okay. I'm just going to scroll through this pretty fast because we already talked about that. Difficulties with police compliance, Fourth Amendment, exacerbated court decisions. Yeah. Yeah. Whenever you have issues, good faith is one of those things that can be used as a good measuring rod for whether or not what's being done is justifiable. That's basically all you're doing is that you can justify and show that those steps taken were taken in good faith. And you're good. Strict compliance binding precedent. David. Okay, so I'm trying to remember this specific case. Now it's going to be a good faith one, but I don't remember the specifics of that case. Acted in strict compliance with binding precedent, which I stated what that precedent was, because there's a lot of stuff related to vehicles. And so in terms of precedences there, it's probably got to do with how long or what types of things that were accessed in the process of effecting search of that vehicle. Because there's been some back and forth on that. I can actually remember those up development board and began. Basically, what it starts to do is it starts to outline the parameters of when you search a vehicle, you have the probable cause search the vehicle. That's probable cause search the vehicle. That's probable cause search glove box and things like that. The trunk, depending on what that specific thing is that you're looking for. Honest mistake. Some honest mistakes and dangerous, difficult processes. They give a good example of it for honest mistake. Let's see. You believe they were in the right apartment, do not realize the mistake until after finding her. So that's just not technically. So it looks like there wasn't anything defunct with the subpoena or the warrant. They went to the wrong address. So it looks like happened in this one. I'd have to look back at that one because I was that one. One dwelling on the property, several dwellings on the property. They searched them all. And yeah, that's an honest mistake, I guess. It was not clear that when the electric was found. Yeah. Okay, this one, brake light. This is the one I was thinking. This is the one that really clarifies it. Honest mistake. And so this actually kind of gets it from both two sides a little bit, because you can see where both sides can misunderstand. Honest mistake here is that vehicles stopped for missing a taillight, right? Just one. However, the state law itself doesn't require there to be two, just one. So you have a functioning brake light, taillight. And so the way it's written, it's one, two. Most people, you got a taillight, I'm going to pull you over. Not realizing that technically in this area, that's actually sufficient. Most people think, hey, that's kind of a normal thing to assume, an honest mistake. Same kind of thing comes with, I don't know if I talked about that here in this class, maybe I did. When it comes to the same kind of principle whenever you're looking at the probable cause element of a warrant. It's not the officer's purview to judge's determination on probable cause. You'll see it also, like if you are dealing with criminal issues, when you arrest someone, it's like, do you know specifically each of the statutes for that particular crime, or do you just know that it's criminal? And so there's a little bit of back and forth in that. Okay, where it does not apply. Yeah. Basically anything that doesn't have expectations of privacy, any place where you're crossing borders, proceedings where you don't have exclusionary rule, where you don't have the not the grand jury hearings. Basically, you don't have any ability to present your own case, that kind of a thing. Probation officers, parole officers, that kind of stuff. What I want to talk about related to that is, actually, I think I've already mentioned that before. Basically, whenever you start dealing with probation and parole officers, since they're still under the purview of the criminal justice system, rights diminish. So the justifications for a search, a full search, zero. If you start looking at the cases that relate to going into someone's home, those were on reasonable suspicion. It's reasonable suspicion for explosives. That's very serious, but still reasonable suspicion. Okay, that was 10, and now 11. This one, do I want to share the screen or no? I'm probably gonna go pretty fast with this one too, because these are very specific subsets. Yes. No, you're fine. Yeah.
My classroom has something.
Yeah. There you go.
Oh, thank you so much.
Yeah, no problem.
Appreciate it.
All right, so as is normal, we'll go through learning objectives for special needs and administrative search. So basically, what we start dealing with are different situations in which privacy can be violated for a bunch of different reasons, right? And these aren't necessarily just. Start looking at it, it's government, but that's not exactly just it. All right, let's see here. Thousands of administrative searches. Yes, there's a lot of them. Not law enforcement officer. They're talking about here. Here it mentions about 9/11, security issues, all that kind of stuff. Is there really anything that I need to talk about on this slide? Not really, no. Kind of interesting things we start doing public buildings versus governmental buildings and weapons things. So depending on the state that you're in, what buildings you're allowed to go into with firearms and that kind of stuff. But that's its own discussion. If you guys want to talk about that, we can. Courts have held that random searches of checked luggage does not violate amendment. Yeah. Sent to inspections by health, fire, and housing inspectors. Okay, so this would be legitimate reasons to enter in someone's home aside from decent reasons. So, electricity, power, water, that kind of stuff. Um, yeah, just general welfare, that kind of stuff. Right. Search warrant must be obtained if a homeowner refuses to allow the inspection, but they cannot be punished for refusal. So, golly, what was, Oklahoma City jail. That sounds familiar? Okay, about 3 weeks ago, was it? Maybe it's longer. I'm on my mind. Like I said, I watch the news a lot, so my sense of time sucks. Several weeks back, the Oklahoma City jail was in the news because it routinely has people dying. Routinely, it's one of those things. It's like every few weeks somebody else dies in there. That's really scary to me. But what had happened was they had some, I think it was health inspectors that showed up at the building, and they refused to let them in.
Why?
That's the question. Yeah, because it's just like this. If you got some type of inspection going, you say no, that's going to give you some opportunity to clean things up before they force their way in. Right? That's exactly what's going on there. Right? That's a huge sign of there being big issues there. Oklahoma City. Oh, I don't know. I'm not familiar with that at all. I just caught it in the news. I was like, they did what? Yeah, they refused. Like, yeah. I'll actually see if I can find that real quick now that that's on my mind. Let's see. Oklahoma County Jail refuses inspection. Health Department, that's what it was. June 25th and July 9th. Surprise inspections. They refused. The whole point of a surprise inspection is to make sure you're actually doing what you say you're doing. Yeah. And so, if you guys didn't see that, I'll show you guys online too, because that just came up. Boom. And so realize that when it comes to the public health stuff, it goes both ways. You got public facilities here. Oklahoma County Jail refuses surprise inspection. Yeah. Yeah. After having, yeah, there you go. That sounds about right. Okay, so some states have passed laws that establish procedures for search warrants may be issued when health sanitation does that kind of stuff. That one's pretty straightforward. School searches is where you start to have some fun. So, public interest best served by, or stand of reasonableness, not stand of reasonableness for short stops probable cause. School officials and quasi-school settings conduct searches of students on reasonable suspicion. So that's the threshold there because of the environment that you're in. It drops down some. Usually they have procedures that accompany that kind of stuff too. Some places, like they might have to have an officer on site, that kind of thing. Let's see, what else does it say? 3 factors to consider when determining whether or not it's reasonable: legitimate expectations of privacy, the intrusiveness of the search, and the importance of those needs. And so that's one of those things where was last class in here or some other, maybe it's a different class. That was criminal law school. We're talking about different levels of to some degree standards, like honesty out of evidence, clear and convincing evidence, reasonable doubt. That's where you start getting over here. It's the level of scrutiny given to it. You start looking at that. And so this is one where they actually start to scrutinize it to a little bit. Now, when you start doing that, you also have to realize that there's different levels of scrutiny involved too. So that one, I'm trying to remember what that is. The only one I can think of is strict scrutiny off the top of my head. And that means it actually shows and must establish that it does serve that interest, right? If it's just a regular, I'm trying to remember what the other types of scrutiny were. But basically, words if you just state that it advances it in some way, like, yeah, it's pretty much all it means. You start getting to stricter levels of scrutiny. You actually have to show, demonstrate that it serves that function, not just that it should. All right, 2-pronged test. Search the back, cell phones, backpacks. Every time I see the two-pronged test, I always think the one on conformance. Okay, so initial search must be justified at its inception. Actual search must be reasonably related to the scope based on suspicion in the first place. So that one's a little bit different than some of the things. That last point, the actual search must be reasonably related to the scope, the basis of the suspicion in the first place. Why? Hey, let's deal with that one for a second. All right, so how do I want to say? Let's say
But when it's a school, is there might
abuses. It's the abuses. And so it's really interesting because this is a bit different than policing. So if you're in policing, that justification of probable cause does not have to be related at all. So long as probable cause was established in any whatsoever, you got full right to stop that person and arrest them. I mean, that's basically where you're at. Here, because you're in that school setting and there are abuses there, it's not related, doesn't count, because you do get abuses there. Yeah. Story time. I'm not going to do story time though. Let's see here. Let's go. Okay. Drug testing. Private businesses may conduct drug testing, but that doesn't apply to governmental employees. So they can test for that at any point in time. Basically, we start testing for drugs. Those are things that are you look at. We'll get to it eventually, the different types of evidence. That one's going to fall under contraband, meaning there is no possessory interest of it at all. There's since it's contraband, its existence is criminal kind of thing, is the way they look at it. And you're a government employee, so we can check at any point in time. Let's see. Interesting, justified testing. This is related to employees in general, right? Here it talks about integrity, public safety, and protecting sensitive information. This is relating to customs employments, customs employees, and your analysis. Typically, when you start moving into drug testing, there are a few instances where they come up. You have the randomized testing that some businesses do. Yeah, and then the one that's unanimous across the board is any type of incident takes place. Workplace accident, workplace injury, really anything. Anything that can have an effect on performance. Because, yeah. All those things have huge effects. All right, trusting law officers. Suspicionless. Most required suspicionless. So just randomized.
Pretty often it's randomized, but usually the same people who picked every time.
Oh, yeah.
I only had to go in once, all 4 years.
Nice. They never did actual drug testing at any places I've been at, but I had seen in accidents where they've done drug testing. I had actually, it's my back injury, I think, when I was 21. I had to go and take one then. Interesting. But yeah, this stuff. What was really interesting to me in high school was the administrative searches and how they're like. We actually had a policy where they were supposed to have a police officer on scene for any of the searches, as far as how many of them took place. There are no officers around, right? Let's pull this person out of class and pat them down real good, have them take off their shoes and socks, kind of thing. Oh, if you don't have anything, go back to class, just for accident. Of course, that's what, a couple of decades ago, so it's one of those things that those times hopefully have changed. But people still do bad things.
Changes that go like rural and urban school systems. Because like if you're in a small town,
They know.
we all leave for hunting season.
Yeah.
So
And they all know who's who and who's into what. Like, yeah. Oh yeah. Let's see here. So many things. Suspicions. Drug testing. Yeah. So drug testing is more and more more and more common. Yours just kind of making the same thing that, yeah, they're officers, so they have diminished privacy. Don't care. Drug testing student athletes. Okay, so with student athletes, drug testing comes in because that's extracurricular. Because it's extracurricular nature, they can require it of you since you're trying to, I guess, I don't want to say, it's not like an unemployment kind of thing, but it's because of that consensual nature and the fact that you want to do that, they have that justification there. Right? It's that reduced expectation of privacy, limited intrusion, and then compelling interest. All right. Yeah, special needs doctrine, like the school boards may require. So basically, leave it to the school boards. And drug testing, extracurricular activities, legitimate concerns. Yeah. Nothing really. Here we go. It's more fun stuff. Okay, so DNA. Basically, what you really need to know has to do with to some degree booking requirements and that kind of stuff. Because if you work into those booking requirements, then you can capture the standard process, right? That kind of a thing. That's basically what they're trying to do here. Of course, they've established databases to analyze and store statutory databases. Certain persons must submit the procedures necessary to collect DNA. So basically what that means is in places where they pass statutes to do this, they'll identify what types of crime categories, types of crimes that they'll require people to submit their DNA, more serious ones, that kind of thing.
So,
yeah.
So, going through airports or anything, like sometimes they'll be doing like wherever. But I don't know where all the categories where you can like for the DNA.
Okay. So when you say what are the categories, like the different types of DNA tests, the different types of it's usually the same types of processes where it's like cheek swab kind of things because it's relatively easy to do for those that do it. Now here it's like any felony, federal government requires any person to do any felony. But it really varies. So it's like it depends on the seriousness of the issue they're dealing with and basically what they want to do. Here it's mainly cheek stuff, that kind of thing. I almost want to talk about COVID in China. During COVID, they had, what was it? Can't remember, Olympics. They were forcibly testing athletes. They were going G-codes. They're going the other direction. That kind of thing. And so it's like there's some intrusiveness here. There can be. It doesn't have to be with this one.
It would just well,
it would depend. It was like how easy the claim is. Like if it's something they're doing on purpose, you'll get people who are hesitant. But it's pretty easy to do. They shut it all the time. Yeah, it's not that hard. It's not good. That should not be going off. About this. I think I've already talked about some of the numbers in the old tests related to DNA. Have I talked about that in here? Okay. Basically, where you start getting into some interesting stuff with this is looking at the tests, their accuracy over time, and how they were interpreted. Anymore, we're identifying you with DNA. Earlier on, like if you look back in the early 90s when it first started coming out, it was more like ruling you out. And that's how they do it. So it'd be like, this is an 80% match. And so we really get to some of the interesting parts is to see the expert witnesses as they're interpreting those numbers as they start putting odds to it, because they'll overstate those. And so that's one of those things that's kind of interesting. because it was not very well refined. And still sometimes it isn't. Yep. Buccal swab method, cheek swab. Search warrants for closely regulated businesses. So when we start talking about closely regulated businesses, of course, that's a term in and of itself that'll give you the definition for it. But basically, what you start looking at is size to some degree. The closer it is to one's actual possession, the less you have to do here. For example, if you start looking at, what do I want to say? Think of it like a business building, an office building. How many different offices are there? How big is the building? How close are they connected? And then what's that? How permeable is basically start dealing with in this regard. Okay. Must be a substantial governmental interest that informs the business operator of the regulatory scheme in which the inspection is to be made. Inspection without a search warrant must be necessary for a regulatory scheme, and that regulatory law must perform two basic functions of a search warrant. So that's how the three requirements authorizing inspections of closely regulated businesses. You have that substantial government interest, so that's that strictness, that's scrutiny, that's a strict, substantial. You need degrees there. Forms a business operator regulatory scheme. So, what is it you're regulating? Mine goes well, just regulate. I just run the office building and electricity kind of thing, right? Yeah. Is it necessary to, was your access to it, that inspection, necessary to further that? And if so, if it performs two basic functions of the search warrant, that law must perform two basic searches of a search warrant. So the law itself. Boom, boom, boom. Work-related searches, yeah, work stuff. It's all there. That's basically what you get out with that. When you're in the workplace, anything that's provided to them is there. So that's going to be everything from offices, desks to computers, that kind of thing. No search warrant needed, no expectation of privacy, nothing like that. It's there. Yeah. It's reasonable for public employers to search for suspected evidence, work-related misconduct. In terms of latitude, these are not governmental officials. So, there's going to be these two things. It must be justified and not unnecessarily intrusive. Unnecessarily intrusive is kind of a hard thing to say. Probably the best way is the way they describe any type of search. Don't go looking for an elephant in a handbag. That kind of thing. I actually forget who said that's exactly how they describe it. If you're looking for a person, you're not going to find it in there necessarily, right? If you're looking for a car, it's like you won't find one in this room. All right. Text messages. Officers' use of pager violated department policy. Found the alleged search of this text message violates health. The review is justified, not overly intrusive. This actually reminds me of something that we had like 10 years ago. That was 12. It's 12 years ago. It's like, think of it this way. Let's think of all the stuff an organization might issue you. Pager, cell phone, laptops, that kind of thing. There was one that it didn't get this bad, but it was state vehicles. University working at had state vehicles for its top level administrators, and somebody had been abusing it, right? And it was driving different places. At that point in time, it had been very, very easy for them to say, okay, let's just check to see where this thing's been at, right? Is there going to be any privacy there? It's like a little bit, not really. That's going to be their vehicle, that kind of a thing. The uses there. Okay. Roadblocks and that kind of thing. So roadblocks are a bit different. I think we talked about those already, though. I won't go too heavy into that. Keep in mind, they have special services they need to serve, and they have to be legitimate interests. They list some of those here, right? The one that's specifically called out as not a reason to have a checkpoint, ordinary criminal wrongdoing. Then you change society. Yeah, special government existed. It could be anything from border checkpoints to drunk driving to probably the one that was the most interesting to stand out was it was a checkpoint for gathering information related to an accident. Had a hit and run, so this checkpoint. You know, traffic's going through, they're asking, and someone was drunk and crashed. And so that's how that one came out as a case. Yeah, they drunk driving or something like that. I'd have to look back at that one. It's texting me. Why are they texting me? Huh. Yeah. Individualized suspicion. Okay, so this is when we start talking about individualized suspicion. So the roadblock itself, the reason why you're allowed to do that is it's only a minimal intrusion. You're talking a few seconds, kind of thing. What happens after that is if individualized suspicion develops, you can have a person pull off. That's more intrusive search, right? That individualized suspicion, though, that's going to be, something that develops basically just like probable cause. As you're there, it can be anything. It doesn't have to be specifically for the purpose of that roadblock, but it develops. There's something criminal going on here. Pull over. Okay. Yep, here's some more of those. Detecting drunk driving, vehicles registration, highways, fleeing criminals, terrorist activities, that kind of thing. Of course, you also have identification of checkpoints in public housing. Identification checkpoints. Yeah, that's a violation. And so that's one of those things where you can run some pretty interesting things in terms of interactions and identification. What would I say there? Incidences. Because depending on the state that you're dealing with, you're talking about the housing authorities themselves. Sometimes you'll have states that will have statutes that allow for stop and identify, right? Just show me your ID. At that point in time, if you're asked that, you have to show it. Those are okay, but this one, yeah, not so much. Okay. Yeah. That's just the same kind of thing you do with any other type of search. Basically, what happened was you had a housing authority set up a checkpoint. Person was driving without a license, notified police. Yeah, police are going to do something about that. They get to. Then, right here, since you don't have that specific purpose, it doesn't stand. Should have stood, but they don't have purpose here. And that's, I guess, just housing authority. So it doesn't mention where it's at. That was a place where they actually had some control over the physical territory itself. Then maybe they're enjoying access to some point. But this is just the roadway. That is really weird. All right, border searches. Basically, anytime you cross the border, you have no privacy at all. The extent of a search here can go really anywhere. To give you an example of the extent, vehicles. They can disassemble your vehicle, right? Right there. That kind of a thing. What's interesting related to border searches here, it'll talk with a little bit about it, search the person's vehicles. Don't require individualized suspicions. I just skipped on. So the interesting thing related to this is how far from the border is the checkpoint allowed? Yeah. That's where you'll run into issues. Start looking at that number. Most are pretty close to the border. I want to say that there's a set distance that they're supposed to be. But not all are within that distance. I can't remember the farthest distance I heard was, but it was more than 100 miles. It's like, yeah, you're not at the border anymore. That's not a border station. That's something else. Maybe. Maybe. There might be an argument there. All right. Forest searches do not require individual suspicion. Okay. Sham roadblocks. There you go. What is it saying there? Fake notices about alcohol checkpoints, drunk driving checkpoints, drug checkpoints, that kind of thing. Why? Changes in behavior. That's another way that they're able to build that justification for a stop, right? If you really get into it, this is more of a procedures lesson. Totality of the circumstances. We mentioned that in here maybe once before. Good. Same situation for every facet of the case. Everything applies. And so it's quite easy to have a situation where there's nothing overtly criminal taking place, but all of those details associated with the situation identify the potential for criminal activity. Border searches are sometimes like that, those roadblocks. Basically, what we start looking at is, okay, what kind of notices have you put out? Where is it you said that they're going to be? What types of behaviors do you see in terms of people afterwards? They're starting to avoid it. You just set up on some of the off-shooting roads kind of thing. They do the same thing with the more permanent checkpoints. They actually have road sensors out there that would feel vibrations. Hey, somebody's out there. And so that's one of those things. Another one would be, I can't remember the name of the case, but that one where the justification was the fact that it was a vehicle which could contain trucks, something like that, contain multiple people, the time of day, the fact they're avoiding the checkpoints themselves that were already established. There's when they saw an officer, they slowed down. The kid there was actually being instructed to wave at the officer to be friendly. So it's like, by the time you get through all those things, not one thing there is directly illegal. Not one. All together, you're like, ooh, that really doesn't jive. And then, of course, yeah, that's what I found. All right, correctional programs. May cause people to incriminate themselves. Basically, here was what it says: diminished right to privacy. Yeah, it's just telling you the same kind of things here. And parolees, diminished rights, basically prisoners in California, since they remain under legal custody of corrections. Most states are like that. I think I really need to say about those blanket strip searches of all. So I probably should talk about strip searches and that kind of stuff. That one we look back up and see if there's a blanket exception. Because every now and again, anytime you see the word blanket, what they're trying to do is they're trying to carve out a blanket exception. Examples. This one I don't know what the status is. I'll have to look that one back up. So, but as a general rule, I think that blanket exception would kick back pretty hard. But you have they try to go for a blanket exception related to what was it? Was it felony? Violent felony arrests, like those ones that have those been attempts to get blanket exceptions to the no knock requirement, stuff like that. Let's see what are the blanket exception ones that's on my mind. They come up every now and again, not too common. There's another one back there. It's going to come 30 minutes. Basically, what you have to do here is you start getting the strip searches or alimentary canal. That's my favorite way to put that one. Yeah, you need to have certain justifications for that. That's much more intrusive. All right. Take evidence in foreign countries. If they're handing it over, it's just fine. Yeah. Acting alone, seeking evidence for to comply with the laws of that country. If they were operating in the United States. So you over there should act like you're here. But if you're doing it for the government, you act like you're here. Yeah. American investigators working with foreign officials. Their activities will invoke American constitutional protections on the part of the subject. So basically, if we're working with others, We have to honor the rights that they don't have in that country. That kind of thing. All right, so that does that one. And then identification stuff's pretty easy too. Let's see if we can get through that. We got 4 minutes. I want to go faster. We'll go for 4 minutes for it. How's that? There's a few different ways that they make lineups, and this first thing that you need to just acknowledge that everyone knows: eyewitness. People don't pay attention. We're not built to pay attention. We're actually built to ignore stuff. That's actually one of the really fun things if you really think about it. Next class, I'll actually show you guys some of that, how bad that is, because it's crazy. And so when you start getting into the reasons for mistaken identifications, you run into a large number of reasons. Particularly, just think about the fact that you're surprise crime, right? Like, how many people are going to be paying attention? Ooh, I can't see that. We're going to check what checkpoints. They put up checkpoints ahead of signs. Yeah, isolated exit. No checkpoints on your state below vehicles getting off the exit. Yeah, that's exactly what they're doing. That is it. They fell for a trap. And that's exactly it. Let's see. Lineups, show ups, photo arrays, that kind of stuff. And so depending on the circumstances associated with a particular incident, identifications can take a few different ways. If it's there on scene, that's going to be a show up. Typically, those are going to happen in such a short time frame, and really based on the parameters of what that incident is, that by the time that you see that person, if you're a witness, there's not been enough time there to lapse to let you forget, basically. The case that had to deal with that basically it was a convenience store robbery that had gone wrong. The convenience store manager, I guess, shot the suspect. Yeah. And so it's like, okay, I'm kind of liking where this one's going. It's at least, the victim gets injured. Okay. So he calls the police, and about, 5 minutes later, someone calls a couple blocks over saying that they'd been shot. And it was the robber. It's like, is this the guy who robbed? Yes, that's the guy who robbed. It's like, so that one's pretty obvious. Photos, everyone knows what the photos look like. Get a spread of those. And the lineups, everyone's seen those depictions. Probably the most important thing we'll pick up on Monday relates to what happens if you can't make an identification, right? How many people make an identification the first time? How many people will be hesitant to just point a finger at someone? Yeah, exactly. And so that's one of the things we'll talk about. We'll talk about some of those cognitive things, and I'll show you some of those filters there too, because good golly, so much stuff gets filtered out that sometimes that's incredible. But I'll show you, there's some couple of videos I like to show that show one, what attention does, and the other one is kind of people's base level awareness. And it's the most important paying attention. My favorite one, I'll tell you about right now because I'll show it to you next time at the beginning. It's a magician kind of guy, and what he does is he's just approaching people. I think in London or something like that. I've got a map. Where am I going? And as he's got this map out, he has somebody come up and interrupt him, and he switches out with another person. And so here's someone else with a map, right? This one has hair, this one doesn't. It's like that kind of thing. Most people wouldn't pick up on it. And so it's kind of fun to see just because people don't pay attention. They focus. But we'll pick up with that next class. But we did it through over a chapter today. Yay. All right. You guys have a great day, and I will see you all next week. Bye. That's right. That's back there. That is so hard for me to see.